Good evening, everybody. Welcome to another episode of Law and Order. We spoke about employees' provident fund and the issues and the legislation behind it and what you could do about it. We're going to move into ETF or Employees Trust Fund and gratuity that you are entitled to if you have been in employment for a certain period of time. And to talk about it and to explain what the legal perspective to the whole thing, we do have with us tonight Mr. Rajiv Amrasurya, attorney at law and also the incumbent secretary of the Bar Association. Good evening to you, Rajiv.
Good evening, Ishad. Nice to be back.
Yep. We spoke about EPF last
Yes.
week, and moving on to ETF and gratuity, something that everyone is entitled to, and especially when it comes to the time when they want to move jobs or when it comes to retirement, that is when people realize that there are certain things that they need to sort out. So if I may ask, is every employer entitled to pay ETF or to the
Yes.
Employers Trust Fund?
In general, it's the same way EPF operates. So government employees, local authorities, local government employees are excluded. And then you have other categories we discussed on EPF, directors. You had that exception on
Yes.
directors, but partners, so and so forth. Domestic employees, chauffeurs and domestic staff are excluded. Then you have even, for example, casual employees, those who work. I mean, there are certain categories like that. But apart from that, generally, private sector employees would be entitled to the protection of the ETF Act.
And we looked at EPF, where you mentioned that employers are to pay 12% or more and employee 8%. When it comes to ETF, do both parties contribute,
No,
or is it only the employer?
It is only
And what's the
it is
stipulated
only the
amount?
employer, and it is 3%.
So that's 3% only of the employer, and that's
Employer,
something that I think
yes.
the general public needs to know, that Employees Trust Fund is only managed by the employer.
Contributed by the employer, so 3%.
So looking at that, what if an employer does not collect ETF?
Same issues as in the case of EPF. It is a liability. You will have to, well, one is you will have to pay it at some point when it surfaces. Then two, there will be surcharges which will get added to the failure to pay. Surcharges are worked on the period in which, or the delay in payment. So you might have to pay surcharges up to 50%. And of course, you will be also committing an offense. So you could be also prosecuted.
So looking at all of this, we mentioned about EPF the whole of last week as to what needs to be done. This overlaps more or less most of those issues and criteria that governs the legislation.
To a large extent, it does. There are differences. The ETF is managed by the board, ETF, the board, and if you have a issue, complaint, if an employee has some issue in the failure or the delay to pay, then you will complain to the board. And then, of course, the board has those similar powers to what the commission has under EPF, and the board can determine whether what is due. And then, of course, you have the mechanism where you can be hauled up before a magistrate, the employer, and asked to show cause. And the failure to show due cause, which is, I mentioned even under EPF, it's a very limited cause you can show. And in the failure to do that, then of course, the magistrate would impose whatever sum is due in the form of a fine. The failure to pay that sum would then may end up, the employee may end up in prison. So, and that's very serious, because actually I think something we could have maybe discussed in the earlier program. Now there have been situations, I've been in some cases, where you have, now sometimes people get onto boards as directors, non-executive, and sometimes, I mean, business corporates, as you know, sometimes you do well, sometimes you don't. There are instances where they, especially now, given the last 2 or 3 years in this country, we had the Easter attacks, and then we had COVID, and I was at a presentation yesterday. I didn't realize that before the Easter attacks, we had elections. So from about 2 elections, and then before that we had that the constitutional coup. So from about 2018 to today, we are in February 2021, things have not been really going too well in Sri Lanka. So corporates sometimes don't do well. So there may be situations where EPF and ETF have not been paid. Now sometimes in situations, people are invited to boards. It is very important for, in those situations, for you to find out when you are being invited to a board of directors, because you are then a controlling member of that company, whether in fact these statutory dues have been satisfied. Because if they have not, and later you have an issue, and if the company doesn't have the capacity to satisfy those debts, then the board of directors also can be hauled up before the magistrates court. And there have been instances where those non-executive directors who had absolutely no idea have suddenly, you know, a year down the line are before the magistrates court trying to defend themselves for a liability which was the company's before they joined.
So that's an interesting part as to what's happened, because we have seen some of the top-notch companies fall apart in the last decade or so in Sri Lanka. So that's something I think everyone needs to know as to when they get an invitation.
When they come onto a board, if you go as an employee, that's not an issue because you are just an employee. But if you go onto a board, then even non-executive, you are a member of that board. I mean, there was a matter where we drew a distinction between executive and non-executive and managed to see, but you may not always have that comfort. You are expected to have done a due diligence, have your due diligence in place before joining. And sometimes what happens is, if you can actually say, well, this happened before I joined, you might be able to have some way out if there is another director who was there, others were there. But if that was continuing even after you joined, and they were not paying EPF, there are companies today who are finding it difficult to pay salaries. And that is not their fault. I mean, the economy is not, I mean, we have had problems. So then if you don't pay your salary, you are also not paying your EPF. And the EPF Act doesn't have a situation where you don't pay. The statutory liability must be paid. So then it adds up. So those are dangers.
So looking at all of it, Rajiv, there is legislation in place to protect the employee. Looking at, say, someone leaves the job, when is the last day for this contribution to be paid?
No, so upon can you
say referring to a monthly payment that goes into the fund?
Yes, yeah? so the last day of the next month, the contribution must reach the ETF fund within a month. Basically, the end of the month, they have about a month to transfer the money.
So, for instance, that is the statutory requirement for the employer to send the contribution. But if an employee leaves the job, is he allowed, as I asked on the earlier show as well?
The same mechanisms are in place. Again, ETF is considered something which you need at the end of your working life, because this is not something you need whilst you are working, because this is again, I called it a forced saving. It's akin to a forced saving, because ETF, of course, you don't contribute, but then whatever it is from your work visits of employment. So there are certain administrative mechanisms in which you can take it out in certain situations. But the general rule being that you have to wait till you finally finish your
So at the time of retirement, EPF and ETF.
And I think it is important to also keep it as long as possible, because you need to have a safety net.
True.
Because now a lot of companies still have the retirement age at 55. This is a retirement age which was probably fixed maybe 100 years ago, 50 to 100 years ago. But now with our health system being much more advanced, it's a good thing. People are living longer. Living, more healthy and can contribute more. So if you retire at 55 and say you live, say maybe till 85, you have another 30 years, which is probably the same amount of your working life, and your income has stopped. So it's not, so I think we need to also as a country look at whether there is some opportunity to extend the retirement age. One is that, I think we are going a little outside our program, but I must say this. One is that sometimes with health system being a more advanced, sometimes you can contribute best at the point of retirement. So when you are at your peak, when you are told to retire, sometimes it's a loss to the country. So that is why maybe you need to, as in the government sector, they have looked at that. But in the private sector, I think it's important to look at those.
So those are legislative changes that you might
I think,
see
and also policy-wise, I mean, I think the private sector retirement age is generally by contract. It's like how some companies say 60, some companies say 55. But I think we need to, as a country, also look at whether we can have opportunity, because it's a problem here. If someone retires at 55 and you live another 30 years, I mean, whatever you save is not going to be enough for that 30 years. So you need to,
wisely invest once you retire. That's something for us to probably ponder about going forward. I'm going to move on from the two funds, EPF and ETF, to what we call gratuity. And if I may ask Rajiv, when should an employer pay gratuity, and after how many years is it actually available?
Yes. How it works is, under the General Payment of Gratuity Act, the general provisions, if you have more than 15 employees, and you come within those category of who employees are in the private sector, then you would be liable to pay gratuity in respect of every employee who has worked for a full 5 years or more. So if you have, and how you look at the 15 employees is in the last 12 months. So you say take the date today. I have an employee. Say I am an employer, and I have an employee who is retiring from my service, who has completed 6 years of service. So from the employee's point of view, he has satisfied that 5-year requirement. Then as an employer, I must consider, in the last 12 months, have I had more than 15 employees? So if I have had more than 15 employees, then I am liable to pay gratuity to this employee.
So
under the Payment of Gratuity Act, the general provisions, there is another provision under the Industrial Disputes Act which says, even if you don't have 15 employees, if you are in a position, this 15 has been fixed because sometimes the employers don't have the ability or the capacity to make this payment. But there are instances where sometimes you have small operations. So under the Industrial Disputes Act, the Labour Tribunal has jurisdiction to go into, even if you are less than 15, whether you should be paying gratuity or not.
It depends on the company's income
you
and
might
revenue.
You might have a high net worth 15-member company, or you might have a small operation somewhere, which is a welding operation, which has 15 members. So it depends. So that again goes back to that principle we discussed in the program for last week, where it is this uneven bargaining power
of the employer against the employee. So looking at that, just like in the case of EPF and ETF, gratuity also has exclusions.
Yes. So again, whether you fall into whether you are an employee who is subject to gratuity. So you have the government. The principle is, if you have to look at it like this, if you are entitled to a pension, then you would not be entitled to gratuity. So government employees receive a pension, so they are not entitled to gratuity. But then we have corporation employees in the government sector, state sector. Those employees are not entitled to a pension, so they are entitled to gratuity. So if you look at it from a general sense, it falls in. Then there are of course certain exclusions, other exclusions like we discussed before, but generally the concepts are similar.
So holistically looking at all of this, Rajiv, what is the rate that employers should pay? And you mentioned about, say, beyond full 5 years of employment,
yes,
you are entitled for gratuity. And how much should an employer pay, and
yes,
what is the rate?
So you have to first, anyway, you have to satisfy gratuity. No, gratuity. The concept is that you are recognizing good service. So anyway, you have to work for 5 years. So that's the thinking of the 5 years, at least. So the payment is that you have to pay half month's salary for every full year of work. So if you have worked for say 20 years, you will get 10 months salary, or 25 years, and of course you multiply it by the last drawn salary. So you might, when you retire, say if you go through to 55, you will be at your highest point of salary. So that salary, half of that into the number of years. Now that is the minimum. There are companies who pay more voluntarily. By the contract, they say, no, we will pay 1 month salary. And that is the incentive to your employee as well. So that is how the computation takes place.
So I think, hope everyone's clear about it. It's just that half a month's salary of the last drawn salary of yours into the number of years if it's more than 5 in that particular employment. If it's more than 5, you are entitled to half a month's salary into the number of years you have been in the company. So that's how gratuity is calculated or computed. And is there a particular time frame, Rajiv, in case, let's say for instance, you'll vacate your job at the end of the month, say end of February. Is there a stipulated time frame for gratuity to be paid?
They have to pay it as soon as possible, but there is no bar. If you have not got it immediate, if you have not got, you can always complain and get it. So there will be time to process. Now recently I heard that I was told by somebody who was entitled to the widow's pension and the government sector. It took about 1.5 years for it to be released, but you have to pay it as soon as possible. And there is no bar on your on the part of the employee to claim this. If it is not paid, then you can always, you have to go to the Commissioner of Labour and like in the case of EPF, make that complaint that gratuity has not been paid. It is now, there was a matter which I did. Now I mentioned, I think earlier, you have a threshold of 15. It's an important distinction here. So if you have more than 15 employees, then you can go to the Commissioner under the Payment of Gratuity Act. If you are of the view that you should be still paid gratuity because the companies or the employees of certain standing, and even though less than 15 employees, they should pay gratuity to you under common principles, then you have to go to the Labour Tribunal, and you have provision to go to the Labour Tribunal and seek. So you have to know which forum you need to go to. But there was a matter where they had gone to the wrong forum, and of course in that case I was with the employer, but the Commissioner has no jurisdiction to deal with a situation where you have less than 15 employees.
So I'm going to go a little out of the box here, Rajiv, when it comes to the particular matter of 15 employees. Say, in case you've been working for a particular company for 10 years or so, and you want to move jobs or you want to retire, and say a year later, or a year before, or maybe 6 months before, there have been a laying off, and say you had 20 employees and now you have only 12. What is the criteria then? Say at the time of you retiring, there is only 12 employees in the company, but right through there have been maybe more than 15.
So under the Gratuity Act, it's the last 12 months. The first test would be to see whether you had more than 15. So if you had more than 15 in any of those months, then you can always claim it. But in your situation, your company doing well, but they laid off employees, obviously for some restructuring, then you go to the Labour Tribunal and say, well, I'm entitled to gratuity. Now it is less than 15, but I am entitled to gratuity, and you can move, and then we will most certainly or most likely be about granted an order granting you gratuity in terms of what the law prescribes.
So let's get to another very important topic when it comes to gratuity. As you very clearly mentioned, it's a gratitude that
Yes.
you're rewarded for
Yes.
the employment of a certain period of time. In Sri Lanka's legislation, it covers as long as it's more than 5 years. But does the employer get the benefit of reducing or deducting a certain amount of the gratuity for a particular reason or the other?
Yes, because it is gratitude. So if you have been an employee not warranting gratitude, there are situations in which you can reduce. Now you say you have perpetrated a fraud. You have simple thing, you have stolen something. You have stolen the laptop and taken it home and not returned it. Now you can't expect the employer to, after all that, have to pay you gratuity in the in the full complement of gratuity. So the law permits you, if there is fraud, misappropriation in situations like that, whatever that loss, it has to be the correct amount to be deducted from what is due to you. So it actually then you don't need to go and prosecute the person somewhere in a court. You deduct that amount. But there are situations where the employment relationship ends not because retirement, but because there is some other issue. Maybe you terminate the person because there is fraud, there is loss. Then you are entitled to reduce that loss, that sum from what you have to pay as gratuity. So the employer also has some protection as long as it's within that sum.
So that's another thing that I wanted to get into, Rajiv. Say, for instance, the company has provided you a vehicle for your transportation, and at the time of retiring or vacating the job, does the employer have the liberty of, say, in the case the employee does not return the vehicle, what sort of legislation covers the employer at that moment?
Yes, so if you can, then you can of course withhold your gratuity. If there is, now it's a company asset, let's look at it practically. Your former employee is now holding a company asset. So that amounts to a loss to the company. Of course, that vehicle may be more valuable than what the gratuity you are paying. And so for the moment you can hold up the gratuity, of course then you'll have to take certain other steps, because then you will be perpetrating an offense under the criminal law that you have taken the vehicle and not returned it. So in those circumstances, the gratuity will not be paid till that is returned, and also you will have to take certain other steps and the other provisions to get the vehicle back. There could be a situation where after employment, maybe the relationship has fallen apart, and parts of the car are removed in return. That can happen, and you damage the car intentionally. Then that is loss. Then you can reduce that amount.
So is there a situation where an employer can withhold the entire gratuity of an employee due to this kind of misconduct?
Yes, so it amounts to what the loss is. So it's a matter of figures. If you have a X figure, and if the loss is more than X, it has to be a reasonable estimate, then you will be able to withhold that sum. And there are instances where that happens and you don't get gratuity.
So just to sum the whole thing up, Rajiv, we've spoken about EPF the whole of last week on the show. We spoke about ETF and gratuity as to what a private sector employee would get compared to what the government sector employees do have a pension at the time of retirement of at the age of 55, or in certain instances 60. Private sector also do have that, but beyond that you see certain companies recruiting as contractors or on contract basis. How does that get affected?
Yes, now that is, they have different types of this contract. Sometimes you have outsourcing, where you outsource work to another company. It happens now a lot. Who is employing those officers? So that company would be paying EPF, ETF, all that. But again, if it comes to a situation where that individual is working in your company like your employee, then you blur this line. Because you go back to what we discussed at the beginning. You have an employer and you have the independent contractor. But this new mechanism seek to, because I think companies also with time, over time will be, legislation is also a little stringent, social legislation. And so companies also don't like to have these liabilities in the long term. In your accounts will say, well, you have, your auditors will say you have to make provisions. So they like to pass on these liabilities outside. If you do it in a black and white way, and if the work comes, that's different. But there are situations where the company can't have the cake and eat it. Either you have them as employees or you have them as independent contractor. The problem arises when you name them as independent contractors. You don't give them the benefits of an employee, but you start treating them as employees. You get them to do work. There are instances where you hire them as independent employees, but you are telling them how to do the work. That's a control test. You say, well, no, this is how you do. Then there are instances where now you start off as independent contractor, but then you put attendance sheet and say you have to come at 8 and go at 5. So, but your contract says you are independent contractor. Or you say, well, no, you have to, and then there are instances where disciplinary procedures. You say, okay, you came late, Now, independent contractor can come late. He has to just do the work. You came late, now we are deducting 10 whatever your day's pay or 50% of your day. So, you are blurring that line. Then you are bringing that person who is now outside in as a, so that is what the court then says, the multiple test, and decides, well, no, this is actually, though you have named him or her as independent contractor or whatever name you give that person, actually one of your employees. Then you get into the situation where EPF, ETF, gratuity, all those other protections you have to give. So it's not when this industrial revolution times and all this started, it was clear. But now I think with COVID and work from home and all those new concepts, you might have your employees working from home, and then you might have your independent contractors who are working from home and who will probably at some point say, well, we work from home, your employees work from home, I am also similar to your employee. And so you need the HR manager, whoever is handling this, has to be very clear in the roles and say, no, you are an independent contractor, that is your, we won't tell you how to do, we won't give you instructions, we won't get, keep that line clear. As soon as the line gets blurred, anyway, even before the labour tribunal, it's a just and equitable jurisdiction. So if it's even slightly weighted towards the employee, the courts will grant relief to that employee. So to that extent, you need to, if you are going to outsource or contract or do whatever to relieve yourself of the liability, you have to do it properly. I said you can't have the cake and eat it.
One final question before we wind off the show, Rajiv, is that say on the request of an employee, the employer decides to terminate his employment and re-recruit under a sister company of the same ownership.
Yes.
How would that constitute?
No. So then of course the employee might, now we have several acts we looked at, might pull out the gratuity. If you pull out the gratuity, then you might be, employer might argue and say, well, it was pulled out, so that period ended. But if you don't pull it out, then the employee can say, well, this was some arrangement, I didn't know what I was signing. They would move me from one to another. I am still doing the same. Sometimes often in the private sector, you find that your employer changes, but you are doing the same work at the same desk. All these 5 companies are in the same building. So on paper, it sounds clear separation, but in reality, you can establish. So in those circumstances, unless it is actually legitimate, you will have a problem at some point, because the employee will come and say, well, work didn't change, I am reporting to the same person, doing the same work, this contract was changed for this. There are instances, and I have come across, where there was a matter where EPF was not paid. Then they complained, right? EPF and ETF was not collected, and the employee had complained saying that I need him. Then what did they? So then they terminated the services. Then waited 2 days, and then they re-employed. That won't work, because now the end of that second employment, they have now claimed they have got for the full period. So just because you draw an artificial distinction, the courts are not going to take that. I mean, courts see beyond.
That's something that the legislation covers, and I think got to thank you, Rajiv, for explaining a lot of gray areas in what employment and employees can do, because as Rajiv very clearly mentioned, this legislation in the country, employment covers the employee and tries to protect the employee for the betterment of their retirement. So that's probably given you enough insights as to what EPF, ETF and gratuity is. So it's time for us to say goodbyes on another episode of Law and Order. Got to thank Rajiv Amrasuri for sharing your expertise, sir. Thank you very much for being with us on the show. It's time for us to say goodbyes. We'll see you same time, same place next week as well. It's bye-bye from us.